You gonna start it over?
Well, then you're missing the mark. You've been putting it
Too late
off
now.
to tomorrow. It's time to feed with the shark. Keep on believing, nobody else gotta see it. Keep on reaching, the stars are aligned and feel it. I said, keep on believing, nobody else gotta see it. Keep on reaching, the stars are aligned and feel it.
Yeah, time to do the Sharks today. Hey, Alicia, how's it going?
What is up? Mute
Not
buttons.
much, man. Mute buttons. Mute it. Let's
Mute
go.
buttons.
We got the shark in the water today. Right now, Dean Tong's gonna be on the show today. Are you excited?
I am so excited. He's not a celebrity. It's not like that, but he's just an expert, like a huge expert.
He is
Right?
the expert. He is the expert in false
So involved.
allegations. He is the expert in false allegations. He's written 3 books. He travels around the country, serving families, helping dads and moms, anybody who's being accused of something that they haven't done, sex crimes, domestic violence, whatever. This guy, Dean Tong, is the expert, and we're blessed to have him on the show today. So I'm Zach Martin, and this is my co-host with me, Alicia. And we are the Noncustodials. So we're excited to have you all on here
I think
today.
everybody knows our names by now.
Yeah, but anyways,
Hopefully.
so and if not, it's written down below, and we're excited. So we're gonna bring Dean Tong in right now, and let him start talking about his experience, what he does. If you have questions for him, please put them in the chat, and Dean will be answering those things for you now. So without further ado, here's Dean.
Good evening, folks.
Somebody pushed
Thanks for
my
having me.
buttons. Hold
Hey,
on.
Dean. She had an intro button for you, but missed it. So
Children. It's children. It's children.
yeah.
Don't
It's hard
you
to
see-
beat, right?
So enthusiastic. He said, "Oh wow."
It's all about the kids.
Well,
It's
no,
all about the kids, man.
somebody was pushing buttons over here.
Definitely it's all about the
I have
kids.
a tendency.
Yeah. To bring in standing ovations? I think so.
No, thank you for having me tonight. I appreciate
Well,
Thanks for being
we're
here.
happy you're here.
it.
Yeah. Yeah. It's one of the shows
And,
that
and kudos to
I've
you.
most looked forward to. So, well, anyways,
Just cut
I
down a
think
little bit
first
there.
off, it's okay. Yeah, a little cut out. I'd like to start off, you're the national expert. I would say one of the leaders, if not the leader in your field. I'd like to have you talk about kind of what it is that you do in court and how you help families out to fight false allegations and give us kind of just a lowdown.
Okay. Yeah. So I'm a forensic trial consultant. I work with lawyers and parents accused all over the country. I've been doing this for 30 years. I usually come in as a consulting expert, and that morphs to testifying expert. So I am nationally certified as a child forensic interviewer. I am certified as a forensic consultant. So I go over strategy and theory with lawyers. I challenge them, as I do the government against me. And basically we try to get to the meat and potatoes is what is your theory or strategy to clear the accused name in court. And so that could be family court, criminal court, juvenile dependency court. You could have an injunction again. It could be on the state child abuse registry list. I don't know if Wyoming has one, but I know Colorado does.
I believe so, yeah.
They do.
Yeah, so there's a lot hanging in the balance here. Not your children and your freedom your reputation, obviously your finances. You can lose everything in a New York minute. And the government only wants 3 letters they want to win, right? They've got all this money invested. They think you did something. You might have molested the kid. You might have physically abused the kid. You might have emotionally abused the kid. It could be a mom accused of Munchausen syndrome by proxy. Now that's called factitious disorder, where you allegedly make a child sick to gain attention.
Can you say that one more time?
To thrive, shaken baby syndrome.
Just basically anything that might arise in any circumstance.
Yeah, it's now called factitious. Yeah. So in a Munchausen case, it would be the doctors and nurses turning the mom in. Okay. So you bring your kid in and you say, look, I think this is what's going on with my kid. You don't like the diagnosis. You don't like the prescription. You don't like, they're going to do surgery or they're going to do this or procedure. You take the kid to another hospital, another clinic, another doctor. And finally they say, you know what? This mother is a problem. We're going to call her into CPS. So the doctors are basically by proxy ruining your life in New York minute. Get on the horn. They call the toll-free hotline number. Social worker shows up. Cop shows up. Next thing you know, you're in juvenile court. And you are charged with basically challenging the opinions of professional experts.
Right.
And basically you have to prove a negative to prove your innocence. Is what it comes down to it. So these cases turn out to be a battle of the experts. You're going to need your own experts to impeach the credibility of their experts.
Mm-hmm. Right. And so you come in as
cases, shaken baby cases. Well, I come in as the kind of the glue between the experts and the lawyers. With all due respect to lawyers, and you yourself are going to be here a lawyer pretty shortly. And kudos to you and congrats
Hopefully.
on that endeavor. But you guys don't get the science in law school, right? You get the law, but you don't get the science. So in my work, when you're accused of sex abuse, we're talking about psychology, mental health, behavioral science, social science. Obviously, a kid comes in with broken bones or subdural hematoma, bilateral retinal hemorrhages. They're thinking shaken baby syndrome, right? The kid was crying. You shook the kid. You hurt the kid. Maybe you killed the kid. You didn't mean to, but it happened, right? Well, as a lawyer, you're not going to know anything about that, right? I mean, come on. So you need doctors. You need physicians. You need subject matter experts. I come in, lawyers bring me in across the country to impeach the credibility of these interviewers. These interviewers use leading, suggestive, direct, repeated, forced choice, negative stereotype inducting questions. Did your daddy touch your pee-pee? Most common question you get. No, bad question. That's leading, that's suggestive, it's closed-ended. It doesn't allow the kid to disclose contextual details. You're putting words and thoughts and ideas in the kid's mind. That's not the proper way to question the kid, right? Did your daddy touch your pee-pee? No, bad question. Can you tell me what happened? Can you tell me what happened, Johnny? Tell me about that. Tell me more about that, okay? So you're trying to get the contextual memory, the unconscious memory to tell the story of what happened. The case law requires that in order for a judge or jury to find the child credible in an out-of-court statement, hearsay statement, as an exception to the hearsay rule that's coming into evidence on the record, that child's statement must be made spontaneously and contain an addition of reliability, an inherent degree of trustworthiness. So you have 3 factors: spontaneity, reliability, trustworthiness. Well, I've given the opposite opinion. No, I think the kid is tainted, contaminated, and adulterated. In other words, the child's not credible. I can't say that. That's Rule 704. You should have learned that in law school. Rule 704, the ultimate issue at bar. The ultimate issue at bar. I can't say whether the kid was molested or not. That's for the judge or jury. I can lead the horse to the water, but I can't say whether it happened. That's outside my province. That is the trier of fact. The trier of fact in a criminal case is the jury, right? In a civil case, petitioner versus respondent, it's the judge. Juvenile case, where a judge can terminate your parental rights, right? That's a judge. Yeah. So my job is to assist the trier of fact to come to a conclusion of whether it happened or it didn't as an expert. There are 3 witnesses in court: lay, fact, and experts. So your long lost grandma from Montana, who knows you're a great father, Zach, knows you're going to be a great lawyer, Zach, but she doesn't know the facts of your case, right? So she has the least credibility with the court because she is a lay witness. Mm-hmm. Now, Mary Jones, the child protective investigator, she's a fact witness. Dean Tong, well, he can give an opinion in certain areas of psychology, social science. So he's an expert witness. So experts have the most credibility with judges and juries. Then it goes down to fact witnesses and then lay witnesses.
Right. You talked about people being able to do this by themselves. A lot of people do go to these trials on their own. What's the value of having an expert witness on your side in these kind of cases?
Well, I mean, I think it's a game changer. I mean, when I get involved in a case, what am I forcing the state to do, right? So the state has to depose me. They have to get my deposition under oath. They have to, find out what the basis of my opinions, the scope of my testimony is going to be. Am I going to testify to parental alienation? Am I going to testify to a botched investigation? Am I going to testify to a botched interview? Am I going to testify to the fact that my accused client of molesting his 4-year-old kid passed a battery of psychosexual tests to prove he wasn't the monster he's been painted to be? What am I going to testify to? Okay, so you're going to match me, Miss Government. You're going to have to get your own expert to match my expertise in court. So they got to hire a PhD or an MD to go against me. Government doesn't usually like to do that. They don't like to spend money.
Right.
They spend enough money, right? Prosecuting cases. So they have 1,000 social workers. They have guardians ad litem. They have lawyers. They have child forensic interviewers. They have nurses and doctors at the hospitals. They have therapists that they ask judges to send kids to. They have an army of allies that they can have play tag team with their case to try to win the case. Let me tell you, you go to a juvenile case. I've been to several. It's me, the expert, my client, and the lawyer. 3 people on one side of the courtroom, 15 people on the other side. It's surreal.
Right.
What is this? Well, that's the way it is.
The weight of the government,
and
right?
As you know, Zach. Well, yeah, it's a loco parentis, right? The state is the parent. Hillary's village.
Yep.
To give a snapshot of it. But you have a right to due process. You have a right to prove a negative. You have a right to prove your innocence, whether it's sex abuse, physical abuse, whether it's emotional abuse, whether it's failure to protect, failure to thrive, Munchausen by proxy, shaken baby syndrome, whatever the case, you have a right to defend yourself. If you don't have the resources, if you can prove you are indigent or informa pauperis under the law, the judge has an obligation to appoint not just counsel, but experts. So I have been allowed to appear authorized by judges in this country in 12 states. I have been on the expert list for Florida and Arizona since 2010, almost 15 years.
Oh.
Wow.
And so in those cases, I don't receive a paycheck right away. I do the work right away, and I get paid maybe 6 months later. When the case is either concluded or it's so far down the road, the lawyer signs off on my work at that point. Right. So that's how that works. I take a lot of cases that way. And I only charge the state 1/2 of my normal fee, so they get a 50% discount.
Oh, wow.
Go ahead. I'm sorry.
I was going to ask, in that situation, when you are appointed by the state, are you still, you're the state's witness, you're the state's expert, or it's for the defendant?
No, I don't work. I don't work for the state, Alicia. I work for the defense.
Okay.
I've been asked that 1,000 times on voir dire, at deposition. Why don't you work for the state? Well, why should I work for the state? You people have thousands of child protective investigators, thousands of child forensic interviewers. You have thousands of therapists. You don't need me. And trust me, I always carry a caseload of 25 to 35 cases at all times. I don't have to look for work because there's so much work out there. It's unimaginable. I mean, today I wonder how many investigations were in Cheyenne, Wyoming. Okay.
Right.
Probably too many.
Not a big state. So,
Yeah.
Maybe they accused maybe a couple of grizzly bears got accused. I don't know. But,
Right.
look, the bottom line is this stuff doesn't stop. You can call anonymously, right, to the toll-free hotline. And unless you're a mandated reporter, you don't have to give your name or your demographics. You call anonymously, and you can ruin somebody's life in a New York minute.
Yeah.
Right.
Little baby next door ran out, and her 2 years old, her diaper came off, and I just think that's horrible. And to me, that's voyeurism or exhibitionism. So I need somebody to come out here and investigate that family. Well, maybe you have an axe to grind with that family.
Mm-hmm.
Maybe there's a long history of motive, method, means, and opportunity because you don't like that family. Whatever.
Right. And then when they do that,
look,
they get
the
a
government
TRO,
does not
right?
do a good job of what's called source monitoring. Meaning they're not vetting or fact checking the allegations.
Right.
They are going with a narrative from a kid, or they're going with a narrative from another parent, an axe to grind, an ulterior motive, right? Maybe a high conflict divorce and custody battle, parenting dispute, whatever. And they're going to run with that narrative, and they're going to align with that belief system.
Right.
You have to be objective here. You have to be open-minded. There's two sides of this coin here.
Right. And they hear that they do it in
So
ex parte.
my job is my what's that?
So, go ahead, Alicia.
Go ahead, Zach.
I'm sorry, I didn't hear.
No, it's all right. They do these. We got a little lag, but they do these ex parte hearings where the accused doesn't even get to be involved, and they make a decision off of an accusation that someone gives, like you said, a family member or an ex who's angry, or just a random stranger, and then that kid gets taken and put into foster care immediately, and then that person's responsibility to then prove themselves innocent, and not having done that after that TRO is over with. Correct?
No, you're mixing apples and oranges there. That would be a CPS shelter hearing where they can take a kid ex parte. But the other one, the other scenario you painted, I think, is more of a petitioner versus respondent, where they're taking out an injunction, maybe on a statement of fear, threatened bodily harm or something. And that's the initial hearing where the judge is going to rubber stamp the mother's, and I say that because, a lot of mothers do this, right? Versus fathers. Fathers do it too, but I mean, it is a weapon, a tool to be used, right? And so, you make this allegation to a judge. He's nefarious judge. He served 3 tours in Iraq and one in Afghanistan, and now I think he's accused is going to have his day in court. Okay, so originally, yes, you're going to get no con, but 10 days later, you're going to have a day. Not much time to story.
Right.
CPS is a whole different animal. When they come in ex parte to do a shelter hearing, that's going to be followed by dependency. Dependency by statute means the child, according to CPS, has been abused, neglected, or abandoned. Okay, that's what that means.
Right.
So they're trying to get a judge to adjudicate the child dependent because they believe that the accused abused, neglected, or abandoned the kid. That's going to go to a hearing or trial. Or if you're an attorney that is not a litigator but a mediator, you're going to tell your client, hey, just consent to dependency, and they'll give you the kid back. Well, not so easy, plan. Not so fast. You'll have hoops to jump through.
Right.
You'll have a safety plan, probably a case plan, and you have to substantially comply. You have to substantially comply with that case plan. So, that could be counseling, could be parenting classes, could be therapy. They try to get you to fail these case plans. CPS does, because they want a TPR. They want to terminate your parental rights ultimately. The difference is on dependency, the burden of proof is it's 51%, and that rises to TPR, which is 75%. Later on, if they take it to TPR and you have a trial, that rises to 75%. So the burden increases.
Alicia asked, why do they want to teach your kids?
But look, imagine this. So the three-ring circus. The three-ring circus is criminal, family, and juvenile court. So imagine you've been arrested for molesting your kid. Okay, you're facing lewd and lascivious child molestation charges. Now CPS is coming after you in juvenile court, and you have a family court case as well, divorce custody. Well, good luck on finding an attorney who can litigate in all three forums at the same time.
Right.
Just a criminal lawyer could set you back $25,000. As quick as you say my name, $25,000. So unfortunately, you get as much justice as you can afford. I did not develop this system. I just became a tool to help the defense defeat this system in what I feel are, if not false, unsubstantiated allegations.
I've had a few different people who have come to me and talk about and told me their stories about getting lawyers who have been on their side to help them out in these cases, and it's been complicated like the ones you've described, and that they've had consultations to do and guidance to do the criminal cases first, let go of the child custody stuff, and then when everything's complete 2 or 3 years later, then they come back, and at that point in time the judges have ruled that they've been gone too long from their kids' lives and that they have to relinquish their rights, or the judge takes their rights to being a parent to their kids. Have you heard of that many times?
Yeah, and this is a factor of the system. Basically let's wait and see what happens game, right? It's a marathon, not a sprint.
Right.
He's been in jail. He's been in jail now for almost 8 years. Almost 8 years. I mean, that's like a sentence in itself. And he's facing, 50 years to life here in Florida. But I've heard of those situations, and lawyers just cannot drag these cases out. You gotta litigate the hell out of these cases. You have to have a bulletproof, unimpeachable strategy and theory very, very early on. So if you have a 4-year-old kid, your theory should be suggestibility, memory source contamination. Right off the top of your head, you should be thinking Dr. Stephen Ceci. If you're not familiar with him, his book was published almost 30 years ago. Jeopardy in the Courtroom. Jeopardy. You'll see it over at Amazon. It's the scientific Bible on child suggestibility. And then you talk about false memories. My other associate, Dr. Elizabeth Loftus, and Dr. Loftus is the queen of human memory, if you will. and her famous book, The Myth of Repressed Memory. And then
Never
you
heard
get
of that
into
one.
the high conflict divorces and custody battles. And what are we talking about? We're talking about Dr. Richard Warshak from
Right.
Dallas, Texas. Dr. Warshak has known me for over 30 years in his book, Divorce Poison, published in
good book.
2008. So, there are a plethora of books and articles that I have, obviously, in my tool chest here on my hard drive, going on 30 years now, and folks should do a lot of reading here. I see people on Facebook, copying and pasting their documents in, ranting and raving about corruption. The system is corrupt, lawyers are corrupt, judges are corrupt. Follow the money. Some of this is true, right? A lot of this is true, but that's not going to defeat the system and get your kid back. Ranting and raving. Go talk to a therapist. You really want to help yourself. Don't play into the hands of the government. And if you don't think that they're trolling you on Facebook, they are. They probably have certain people that are looking for you to screw up on Facebook or TikTok or wherever, so that they can nail you, because all that stuff can be legally admissible into evidence onto a court record. And all of a sudden you wind up seeing yourself on video or pictures or posts on Facebook come into court against you later on in court. So be very careful.
Yeah.
I don't know how many times I have cautioned people, don't be your own worst enemy.
Can you give some advice to anybody that might find themselves in this situation?
I usually
Go ahead. Just the first step they should take.
Well, it's hard not. It's hard. Yeah, it's hard. It's hard not to panic. Obviously, these cases are very, very closely to the vest. Very emotional. It's about your family. Your livelihood, your children. And certainly, it's not just what you know; it's who you know. So don't let anybody in your house without a warrant, right? There was a thing called the Castle Doctrine that protects you, make sure they identify themselves. I tell everybody in today's world, 2024 America, get a body cam, get a body cam, wear it. If you have to wear it to bed, wear it to bed. Seriously. You can't have enough accountability. And one day you might be in your car alone and there's no witnesses, and that body cam is your best witness. It's your best transparency, because you don't know what's going to happen. You might wind up picking up your kid at your ex-wife's house, and all of a sudden you're set up, you're ambushed, and you have no way to combat this situation. So, and I don't care, if your state is a two-party state and you need permission. Wear the body cam anyway. Worry about, they're not going to arrest you, for taping against somebody's prison. It's not going to happen. Admissibility, worry about that later on. But get it on audio, get it on video, and go spend your $40 at Amazon and go get yourself a good body cam. Mm-hmm. And do a timeline. Go in the word processor of your computer and work up a chronology, a journal by dates and events, and go back to before the Titanic hit the iceberg, before your relationship blew apart with your ex, when everything was hunky dory. Go back and jot down significant dates and events. What happened? How did this relationship go south? She started gaslighting me. She said I was hitting her. She was hitting me. He said, she said, whatever. Maybe the child was allegedly a proxy witness to domestic violence. That's another thing, right? You could get in trouble for. So have it all written down in the timeline. Lawyers should be asking you for a timeline. I require all my clients to give me a timeline. I want to know how this case came to fruition. How did we get here? When I get a case, I try to glean, where was the case? Where is it now? And where are we headed? Where does it go? What do you want out of the case? If it's a custody case and it's now in criminal court, you've been arrested. Obviously, you want to clear your name. You don't want a felony. You don't want prison. You don't want sex offender registration. Maybe you want sole physical legal custody. If that's what you want, I'm going to try to get it for you. Now, I'm not your lawyer. I'm the running back. But oftentimes, I score the touchdown. Zach is your quarterback. He controls the litigation. But who's the guy on the witness stand? Who is the guy who goes through direct and cross and redirect and recross? That's me. Of course, I'm not the only one out there, but I've been doing this a long time. And I've seen great psychologists. Look, no disrespect to the doctors out there. I've seen great psychologists, great psychiatrists, 100-page CVs, 20 books in their name, and they blow up on the witness stand. Not only did they not help the accused and the lawyer, they made it worse. They poured gasoline on the fire. You might as well be part of the government. Horrible.
Terrible situation.
I put a post out earlier tonight. And I'm not going to mention her name, but she's a great expert. But she only does blind testimony. Well, blind testimony means she's not looking at the records. She's basically making hypothetical opinions as an expert. Sorry to tell you, that doesn't help a lot. A judge and jury wants to know the facts of the case. A judge and jury wants to know, how does your testimony form a nexus and a link and a connection to that case at bar? And so my job is to help the lawyer intersect the alleged facts with the facts and the science and the law. If you connect those dots in court, you should win your case.
We talked the other day about.
I've gone up again. Go ahead.
We've talked about the other day about the lawyers you get. A lot of people get a lawyer. They just pick any old lawyer, right? If you're in these kind of cases, what kind of things should you be looking for to get from your lawyer? What kind of lawyer should you find?
Yeah, so there's a section in my book, Elusive Innocence, at my website, abuseexcuse.com, How to Choose Your Attorney. Same title in the book at the website. Your lawyer should be a specialist litigator. In child abuse cases, you don't want a mediator. If you allegedly molested your kid, it's black or white. You did it or you didn't do it. It's not a gray area, so you don't want a mediator.
Right.
You need a pit bull. Okay, so that lawyer should be board certified for whatever law he's practicing: family law, juvenile law, criminal law. They put you on the abuse registry, administrative law. If you're filing a lawsuit for damages, civil rights law, board certification. AV rated, Martindale Hubble. Great AVO ratings, avvo.com. #1 legal review website, and then the lawyer should give a free consultation. And then you want to know what his retainer fee is, of course, and how does he bill. And look, the first thing you learn in law school are 2 words: billable hours. Billable hours, right?
It's like the most important thing to teach in law school.
Especially if you're going to become a part of a multi-law firm. Yeah, well, and look, I have to get paid too, right? But whether I'm getting paid for in an indigency case, 50% discount, or I'm getting a regular retainer fee, for me, it's more than a paycheck. I want to win, and you guys probably know I have walked in the shoes of the accused, right? I've been through this. That's how I got started 40 years ago in Florida, right? So I have lived it. I know what you're going through because I have been there. It's very surreal. I was arrested for allegedly molesting my 3-year-old in Florida 39 years ago. So I know what you're going through. And you have to dig deep down to your bone marrow to get the emotional fortitude to be able to fight through this. So it's not easy. You're going to need a support group. When I was going through this in the mid 80s, man, they didn't have computers and internet and and Google and Facebook and iPods and iPhones and iPads, any of that stuff. I mean, you got to be kidding me. We had Westlaw, we had LexisNexis, we had a little brother word processor that might have had a 3-inch by 6-inch screen. That's all you had, and a law library. That's all you had. Yeah. No disrespect to the folks of today, but you guys got tools I wish I had. Going through this stuff in the mid '80s. And I still won all my cases pretty much back in the mid '80s. But I'm from Boston, right? So in Boston, we just have a different DNA. I started telling my lawyers what to do. I said, look, you guys are screwing up. I'm babysitting your work, whether you like it or not. If I'm going to go down, I'm going to go down through my own research. So I had a bunch of lawyers.
You just went full pro se?
No, I never went pro se. But I, you see me talking in court. Judges got on my case. Mr. Tong, you can't talk in court. Well, excuse me, Judge, I'm whispering. And I have a right to attorney-client privilege and due process in this courtroom, Your Honor. He's banging his gavel. I said, what are you going to do? You going to hold me in contempt because I'm talking to my lawyer? Really? And then I started making the media, and I would tell judges, I said, okay, you're going to get tough on me. Maybe you want to be on CNN and Nancy Grace tonight because that's where this is going.
Right.
I can guarantee you, there aren't many talk shows I haven't been on. So you got to be tough, and I don't mean to be disrespectful. You've got to be polite. You've got to abide by court orders. But this system will run over you like a freight train if you let it.
Yeah.
And with all the cases that I have worked, with all the families I have helped, it is nonstop. It doesn't stop, and the reason it doesn't stop are the laws, right? So we look at the laws, and you look at CAPTA, Child Abuse Prevention and Treatment Act from 1974. That has never been really repealed. The CPS has 11th Amendment immunity, right? You can't sue CPS for money as a state agency. They're still undereducated and undertrained. My book, Elusive Innocence, Dr. Cece's book, Jeopardy in the Courtroom, should be part of their curriculum. In all 50 states, it should be part of their curriculum. Because if you reduce the number of false accusation, unsubstantiated cases, you'll be able to protect those kids who really are being abused. Clogging the docket, stop clogging the court system with witch hunts and fishing expeditions, right? So, sorry to be crass, but this is reality. And you have to look at the trauma to not just kids who've been raped and physically abused and human trafficked, but you have to look at the trauma to non-abused children who've been treated as if they have been abused, but they haven't been abused.
Right. Yeah.
But perhaps they have been by the system who's tried to get to the bottom line. Therapists who are well-meaning, well-intentioned, but misguided. Instead of avoiding harm, they introduce harm. They pour gasoline in a fire. CPS agents who go in with this confirmation bias, preconceived notion. This is what they think is going on. This is what they think who did it. Any other theory has to be proved by the defense. That's how this works. A lot of people, they disagree with my theory, but I can tell you this. I have a pretty successful track record. I just have to work as a three musketeers with my client and the lawyer. That's not easy to do.
Yeah. Keep them both in line and getting to the points you need to be at. How often do you find yourself coaching the lawyers, and are most lawyers receptive to your guidance on how to handle these cases?
Well, I never tell a lawyer I'm babysitting your work. They don't like that. They have huge egos. They would probably tell the client, Donald Trump him, I'm not going to stand for that. So I do it because I don't want to get in my lunch eat on the witness stand. I can't avoid that, and I have a national reputation to uphold. But in essence, I am babysitting the work of the attorney, the case law, the statutory codes, whether they know the facts and the alleged facts. Perhaps in the court documents they glossed over something they think is unimportant. I think it's important. And there are issues in psychology and social science where really I don't have time to be educating and training the lawyer as well as a client on what this stuff is, and yet it's very important. We're talking about memory, how memory works. Memory is encoded, it's stored, it's retrieved, it's reported, and then it's amplified. And so human memory is not a perfect videotape. It fades and decays with the passage of time. You may not recall what you ate for breakfast 4 weeks ago today. Probably won't, right? You may not recall all the details of what Uncle Johnny did to you 2 years ago, or 10 years ago, or 20 years ago, right? I get cases that go back not just months and years, but decades. I've had a few cases go back 20, 30, 35 years. Yeah. And so memory. So my original thought to the lawyer defending the accused is, why don't we put the accuser's memory on trial? Oh, I never thought about that. Okay, well, I'm asking you to think about that. And if I'm not going to be the testifying expert, I can at least be the go-between between you and the expert who I think you should retain to be the testifying expert. Obviously, I've been in this field professionally since '95, been involved since '85. So, when you're doing something in life, right, the names, you hear them over and over again because you're in the same field. So, obviously, they know who I am. I know who they are. And I have all these names either in my head or in my database on my hard drive in my computer. I used to have names of fathers' rights activists, across the country. We had fathers' rights groups I used to belong to back in the 80s. I used to be an advisor for ACFC, the American Coalition for Fathers and Children. I gave conference presentations in Washington, D.C. I don't even know. Yeah.
I don't even know.
So,
we should find out.
I
Yeah.
don't think they are. I haven't heard of them.
There are groups. And look, this is not a gender biased issue. So I get mothers that call me, and of course I appeared on Dr. Phil 20 years ago in 2004 with a mother who was falsely accused of coaching her twin daughters to accuse the father of incest. And I appeared on Dr. Phil with her. And we did a few other shows besides Dr. Phil. And we won that case. We won that case on appeal. My point is, there are a lot of mothers out there who lose custody, who are falsely accused of coaching their kids to wrongly accuse the dad of child abuse. Perhaps parental alienation, falsely accused of parental alienation. It cuts both ways. So, parental alienation being, of course, emotional, mental, psychological child abuse. But there's another prong to that test. So even if you're lucky to have an expert testify and get a judge in Wyoming to admit that into evidence on the record as a bona fide, not junk science, parental alienation, that is, you have to prove the harm, the degree of harm from that alienation to the child. So there's another prong to that test. In order for me to do that, I have to see records. I have to see counseling records, medical records, perhaps messages on behalf of professionals relative to the children, and the level of trauma due to the parental alienation.
That's pretty much everything. My goodness. How
I
many
testified
states?
in a criminal case.
Go ahead.
I testified in a criminal case last March 2023 by Zoom, which I wasn't sure if I could do that, be a criminal case, but the judge allowed me to. And the lawyer apprised me that as soon as I came on, the judge was skeptical of the science of parental alienation. So I said, Your Honor, I agree with you in part. He says, oh? I said, yes, sir. It's not published in the ICD-11. It's not published in the DSM-5-TR. However, there was an article in 2022 co-authored by Jennifer Harmon out of Colorado that the science literature review was done on this science, and they found 213 peer-reviewed articles on the science of parental alienation. Then another article came out last year in Youth and Children's Services Review on the same topic, but based on unsubstantiated false abuse cases consistent with parental alienation. So there's a lot of scientific articles on this subject matter. Coercive control. You probably have handled that issue as well. So we see women who are domestically abused, they are victims of coercive control, right? But now, if you are manipulating the mind of a kid in an alienation type case, that could be coercive control.
Right. What was that? Where was that bill at, Zach, that we were looking at a few weeks ago?
That's a
The Texas bill.
Maybe it was a Texas bill, but it was like they changed everything and they took out the parental alienation part, but they put in coercive control. But the way they described and defined coercive control, it was what parental alienation is. That's how I read it. It was just really interesting to me. But so it's neat you bring that up.
Well, yeah. So, that is obviously a controversial theory still. A lot of groups out there think that the actual abuser is getting off the hook or beating the rap and is using the tool, the weapon, the defense of alienation to get custody of the kid.
Yeah.
You're probably going to need experts.
Yeah, in law school, I mean, they're teaching that parental alienation is not a real thing, and it's junk science. And they have a paragraph dedicated to it in the family law textbook, which we do not cover, even in our class. And then
some of that bad rap, Zach, goes back to my associate who created this theory over 40 years ago, Dr. Richard Gardner. And he was accused of pedophilia himself. And I mean, the level of extent that the, for lack of a better term, women's groups go to, or true believers or child savers go to discredit science that has been empirically studied, has been replicated, has been validated time and time and time again, is nauseating. Just because, and look, I won a case with Dr. Burnett a little over a year ago from his home state of Tennessee. He's the author of the 5-factor model. You've heard of the 5-factor model?
Yep.
I haven't.
Okay. So
sorry.
Right. Okay. Well, all right. Well, the 5-factor model, Alicia, basically says that the first factor is the child is rejecting the accused. So the child's gone from resisting to disconnecting to rejecting the accused. I don't want any visitation with you. Don't call me. Don't see me. I don't care if you have a court order. I don't want anything to do with you. Okay. Second factor is, but the accused can show through video, audio, and pictures. At one time, they had a great relationship together. Third factor is the accused, the targeted parent was falsely accused of abuse. They can prove that through CPS records or unsubstantiated findings by the government. Fourth factor is the signs and behaviors of the child are consistent with alienation. And the fifth factor is signs and behaviors of the mother or the alienator are consistent with alienation. So that's the 5-factor model in a nutshell. And then Dr. Burnett went beyond that to talk about what's called PABs, parental alienating behaviors. But the point is, we did a case together. He was great. He did a PowerPoint presentation in that case. I was the consulting expert in that case. He testified. We won, and they had experts who would say, "Well, it's not in the DSM-5. It's not in the IC. It's junk." Judge, it's bogus. Come on. I mean, and so I got an email from him, Dr. Burnett, and Dr. Youfik. That's Youfik. She is the steering committee head for the DSM committee. So she actually is the decision maker on what disorders get in that mental health Bible, the Diagnostic Statistical Manual. And she said, look, it's already in there. Parent-child relational problem. Parent-child relational problem is already published in there. You don't need the word alienation. It comes in through that. The negative thing with alienation is it intimates malicious estrangement. I'm going to estrange that kid for you. I'm going to keep that kid away from you, right? And so that's not science. That's just a thing. And that's what the the non-believers are putting out in writing, in articles, in books, talk shows, whatever, that this is junk science. The fact is, CPS, if you look at your own CPS policy and training manual for Wyoming, Cheyenne, wherever you are, you will find a topic on emotional abuse of children.
Yeah, definitely.
It's in there. So that's what this is. It's mental child abuse. It could be gaslighting. It could be denigrating, vilifying, disparaging the other parent in front of the kid. That's what Dr. Gardner used to call PAS, parental alienation syndrome. Yeah. I don't ever use the word syndrome when I'm testifying, ever. Munchausen syndrome. I don't use battered women syndrome. And the reason I don't, judges don't like syndrome evidence. They think it's anecdotal behavior. It's not science. So as an expert, you have to articulate your findings and opinions relative to science, relative to principles and methods. You have to. Otherwise, you're going to get impeached. You won't be able to testify. You won't pass voir dire, which is a critique of your qualifications. So, and I think I don't know where this is going. If you ask me to look at a crystal ball, will one day parental alienation be published in the ICD, International Classification for Diseases, or the DSM manual? I don't know. I think it's a Las Vegas crapshoot. But we have parent-child relational problem. We have child affected by parental relationship distress. We have estrangement. We have child psychological abuse. It's all in there already.
Right.
And these are the ones I
Coercive
testify
control.
to. And all I try to do is basically conjoin the alleged facts with the diagnosis based on the records and science and behaviors. So with an alienator, right, the alienator wants to enmesh the child to the alienator, right? They want the child to lose emotional attachment with the targeted parent, with the accused. They want 100% enmeshment. Well, that same alienator does not have what's called ambivalence. They lack ambivalence, meaning they will not have mixed feelings about the situation. They won't be open-minded. As an expert, we're trying to look at what's other possible explanations or reasons for why a kid is saying what she's saying or what he's saying, or why this case came to bear in the first place. So So if you're in a criminal case, the job of the defense is to put reasonable doubt in the minds of those jurors. My job is to give as many theories to the lawyer to articulate to the jury and the judge to get to reasonable doubt, right? Because the state has to prove their case beyond a reasonable doubt. That's a very high number, by the way. It's about 95% to get to beyond a reasonable doubt. It's a very high number the state has to get to. But in these cases, in my cases, the accused is presumed guilty. You have to prove a negative to prove your innocence. And so I usually require my clients to go through a psychosexual testing, if it's a sex case, to show that I don't show any sexual interest in little girls. I've only had consensual relations with adult women my entire life. Well, the kid said that you told her to keep this a secret. Don't tell anybody. Because if the kid said something, you're going to hurt the kid's mother. So how does a lawyer impeach that? How does a lawyer get to the bottom line of that he said, she said secret without having empirical raw test data that the accused does not show what's called cognitive distortions, which are justifications. So we get actual pedophiles and child molesters who will try to justify their own abuse. They will try to be con men, trying to hoodwink the entire system. Those are few and far between, but they do exist. I've had a few. I
was going to ask you that.
Most, Not all my guys, not all my clients are clean. There are bad apples out there. There are guys who actually do this stuff and they're guilty.
Try and get out of it.
I am not a how to get off a beat the rap child abuse guy. That's not my job. My job is that needle in a haystack. I want to get to the truth, right? So I do my own internal investigation. That's what I do. I hold everybody to evidence-based best practices. I hold everybody to a trauma-informed risk assessment therapy regimen, and that just doesn't include if the kid has been abused. Trauma-informed also goes to false accusations, the trauma to the accused, the trauma to the non-abused child potentially.
All right.
But I would dare you to go to psychologytoday.com and put in whatever area you want to put in and try to find any therapist, just one, who specializes in the area of false accusations. You won't find one. Mm-hmm. You will find trauma. You'll find sexual abuse. You'll find addiction. You'll find all these issues, but you will not find false accusations. So good luck in finding a psychotherapist who can help in these situations. And so one of the first things I ask a lawyer is, okay, well, your client's accused of sex abuse. That's a trauma, right? That's a trauma. If the kid's been molested, the kid said, "Daddy touched my pee-pee," or "Daddy put his pee-pee in my pee-pee," or worse. If that happened, that's a trauma. Well, it can also be a trauma if it didn't happen, and that's what the system has seen. Those studies have been around for some 30 years. The effects of false accusations upon children and families was published 30 years ago. So. And so my job is to also provide the lawyer with what's called, and I'm sure Zach learned this in law school, learned treatises. Learned treatises are seminal peer-reviewed journal articles, books and book chapters. That can actually, those book chapters, those articles can actually come into evidence onto a court record through an expert's opinion. I don't have to be the author of those books or book chapters or articles, as long as I'm aware of the information in the same. So it's helpful. And look, every case I get, it's not just helping the accused and the lawyer, it's an education, right? There are things I'm learning, and I'm in my late 60s, and there are things that the lawyer's learning. I don't want it to be a CLE seminar for lawyers, but sometimes it happens. You know, even with judges, you know, I've ticked off a few judges in my career. Well, you're going to give an opinion on the therapist treating the kid as a sex abuse victim before the merits of the case has been heard and adjudicated, and you're going to say that that is possibly pouring gasoline on a fire? I've never heard of such a thing. Well, Your Honor, with all due respect, perhaps you haven't read Dr. Scott Lilienfeld's article from 2007, First Do No Harm. Therapists are supposed to take an oath, just like physicians, to first do no harm, right?
Yep.
So, you know, if you're in a child sex case and the government's recommending to the mother, hey, mom, you got to place your kid in therapy. Mom does so. Well, the kid's not there for cancer or bulimia or anorexia. The kid's there to be treated as if she has been abused. That's why she's there, right? So a therapist is going to buy into that, is going to make $60 an hour, and is going to treat that kid with EMDR or TFCBT as if she has been abused. She's aligning you with the kid's belief system, right? Look, in a criminal case, in opening statement, the first thing you'll hear from a prosecutor, kids don't lie. Kids are not mistaken about sexual abuse and assault. They must be believed and protected at all costs. You're going to hear that, and you're going to hear it ad nauseum. And what does that do? Well, it biases the jury immediately, right? That's the job of the prosecution. Right. That's the job of CPS, the judge, is to bias that trier of fact against the accused. Oh, okay, well, 4 days have gone by. The state is done with their case in chief. Now it's the defense turn. But yet the person you're trying to influence is already biased against you. You know, to mention Donald Trump for 1 second, he's at trial right now, right? And fact is, the state, the U.S. Attorney's Office is putting on their case in chief to bias the case against Trump very quickly, right? That's their job. That's what they're paid to do. Right. So that's how this works. And you know, and I see so many people on Facebook say, "Hey, Dean, my lawyer didn't put the evidence in." You know, we had deposition transcripts. They weren't even referred to at trial. So look, I can't force your lawyer to do or not do anything. I can only suggest or recommend to your lawyer to do stuff. Lawyer can tell me to go flip off. You know, right. It's up to your lawyer. If you lose, you have a right to appeal. Good luck on that one. Your chance of winning is 2%. 2%, 2 out of 100. You might be able to appeal for abuse of discretion by the trial court. If you lose that, then you get a second shot at your lawyer for IAC, ineffective assistance of counsel. I'm on 3 criminal cases right now, 3 from different states where trial counsel allegedly failed, and the accused has successfully appealed to this point for IAC against the trial lawyers. So that's a good barometer right there. You know, that lawyers just don't get this stuff in law school. This is not taught. False accusations are not taught to social workers, child protective investigators, right? My books are not there. Dr. Cece's books aren't there. The articles aren't there. You know, and so these child protectors, they're not all bad. You get some good ones there, but some of them, they need a further education and training. You know, they've got to be objective. So I'm sure they see a lot of horrific abuse. I'm not denying that fact, right? But when there's a kid being abused down one end of the street, right, there's another witch hunt down the other end of the street. Yep. Where a family is emotionally traumatized and they spend $10,000, you know, basically their life savings to try to keep their family together intact and keep their loved one from going to jail.
Can you see the comments, Dean? Sorry.
No.
No, I'm sorry. Oh, how do I hire this man?
Yeah.
My website is abuse-excuse, There is a consult page there at the website. It's a form. It's called an accused questionnaire form. I give everybody a complimentary response. If you pick up the phone and call me, my numbers are at my website. You also get a complimentary, talk session with me to hear your story. If I can't help you, I'll try to guide you to who I think can help you. I'm sure I'll give you some thoughts and ideas what I think you should do. But the reality is I'm not a lawyer, but I've worked cases from all 50 states. I've had three from Hawaii and 3 from Alaska. Only 1 from Wyoming, and that was quite a while ago. So, it is a situation where I just have to have a marriage with the attorney and the accused, and whatever court it is, I've been there, done that. So that includes lawsuits. I have assisted in Title 42 USC 1983 lawsuits for breach of proper standard of care and professional negligence against governmental officials, whether it's police officers, child protective investigators, whomever. For those of you who don't know, I will tell you the police have less immunity than CPS. The police come under the quasi-prosecutorial or qualified partial immunity law. CPS has a total blanket of sovereign 11th Amendment immunity unless you're suing the individual caseworker in their individual capacity. As soon as your lawyer mentions the word official in the complaint, you will be dismissed. I can assure you, you will be dismissed and perhaps held to Rule 11 sanctions.
No lawyer likes that.
No. Which in other words means you're going to pay the attorney's fees for the government or the state or whoever you're suing. You're going to pay their fees as well. So, yeah.
It's ridiculous.
It's all about making fees. That's why it's not about paying fees. It's about making fees. That's what the lawyers are taught.
Yeah.
So, kind of sum it up here at the end. When someone gets accused of false allegations, kind of give us the, elevator pitch breakdown. What should they do? Who should they call? And how can they protect themselves and their children from being abused?
So first thing that happens is you might get a knock on the door from a police officer and CPS. I already mentioned about the castle doctrine, right? You don't have to open that door. You can talk through it without opening it. If they say they have a warrant, of course, you want to see the warrant. If it's an official warrant, they may be looking for your computer, want to get your computer, confiscate your computer, look for what used to be called child pornography is now called CSAM, CSAM, child sexual abuse material. Child sexual abuse materials is now called CSAM, right? But my point is, you could be placed under immediate criminal investigation if they take your child based on probable cause that the kid is in imminent danger, and they can do that. They best practice says the child is supposed to go to the Child Advocacy Center, the CAC. All states have CACs to interview and do the medical rape exams within 3 days. Within 3 days of the child making an outcry. So if the child made an out-of-court statement to mommy or daddy or grandpa or grandma or Uncle Tom or Aunt Mary, whomever, this man touched me, and usually it's a family member or someone the kid knows. So the stranger danger child molestation is more myth than a fact. Okay, that's usually not the case. It's usually someone the kid knows. The kid's going to go to the Child Advocacy Center for that forensic interview. That's going to be observed by a cop, a sex crime detective, and a CPI from CPS. The interviewer is certified, like I am, to conduct that interview. That means the rules of criminal procedure have now been engaged, which means the accused is under immediate police criminal investigation because there's a cop watching that interview. If the child implicates the accused during that interview, yes, he touched my vagina. Yes, he touched my butt, whatever. You got to be on the horn to a criminal defense attorney because you are now in what's called the criminal interference stage. Okay, you haven't been arrested yet, but you're in the criminal interference stage. You're trying to stop an arrest warrant from being issued, or the cops just coming to get you. So you want to get a lawyer because what the lawyer is going to do is start making phone calls with a sex crime detective, and that could, that'll alert the detective. You mean business. You have a criminal defense attorney. And then the sex crime detective will say, listen, we're going to go ahead and prosecute your guy. We're going to come, we have PC, we have probable cause. We're going to come pick him up. I witnessed the kid's interview. The kid implicated your client. We're coming to get him. You will be turned in. You don't want to go on the lam and try to avoid justice, right? Like O.J. Simpson, who just passed away last week. You can't duck for cover. So your lawyer will turn you in. You'll be issued a bail bond. You'll be issued a no contact with the victim, and then it's basically Dean Tong time. You are now laying out a strategy to prove a negative. Well, that's going to be months in the process. It's basically a marathon. And the state tries to delay these cases. Your lawyer will probably sign off on a waiver for your right to speedy trial, which is 175 days from the date of your arrest, because the lawyer's just not ready in 6 months to go to trial. So you haven't seen your kid in 6 months. Kids in therapy being reinforced that you did this. May not be any medical findings. Usually there aren't. 95% of these cases are he said, she said, what a child said, hearsay. And you're swimming upstream and you're scratching your head. What the hell is going on here, right? Perhaps I should have been the first call, not the last call. There are cases where guys call me, women call me 2 to 3 years after the bow has broken, and you're asking me to be David Copperfield. I can't do that. I'm not a magician. So the earlier the better. Oftentimes I will help the lawyer. There are a few states like my state of Florida that allow depositions in a criminal case. I don't know if Wyoming does. Zach, you would know that in a criminal case. But that's a great tool, right? So here in Florida, we have to get permission now, but we can interview kids under 16 in Florida with permission from a judge. So it's a great tool to have to know early on what the kid said at deposition under oath. And now you're going to go to trial 2 years later. We're going to compare and contrast what you said to look for inconsistent statements, right, under oath at depo versus trial with the kid. You will get your Sixth Amendment right to confrontation. You'll be facing that kid at trial, even if it's your own kid. But the state could file a motion that the child is so traumatized, the child needs to testify in a separate room by CCTV, closed circuit television, where the jury and the judge and the gallery and the lawyers and you, the accused, only get to see your kid through a TV screen. That's possible. So, look, there's nothing I haven't seen over 30 years. Every trick in the book that the state has, I have seen, either on me or in a case. It's like going to sleep at night, right? You just get used to it. So you just got to have thick skin. All about preparation. You got to have, you got to be prepared. You should know before you go to trial, you've already won the case before you walk in that courtroom. Seriously.
Right.
and so long as your lawyer has got his plan of attack down to a science, you have dotted all your I's and crossed your T's, you should be ready to go. And hopefully, you become the intimidator. You put the fear of God in the state, not the other way around. So the state has to null pros, or the state files the defense lawyer files a motion to dismiss. It's granted, or whatever the case. You put the fear in the state, because the state has invested a lot of money to take you down. Whatever court you're in, juvenile court, criminal court, and even on a family law case, petitioner versus respondent, it's a lot of money. Yep. And even if you're pro se, it's still going to cost you some money. You want to get transcripts typed up and transcribed. You got to pay for those. You want to have an expert, private investigator, whatever the case may be. It's all going to cost some money. So the key is to not throw away tens of thousands of dollars early on lawyers who are impressive over the phone, who in marketing and propaganda at law school scored an A+. They got your retainer check, and then they didn't do anything for you.
Does it happen very often, you think, that somebody will retain you and a decent attorney, and the state sees like, oh, whoa, well, they got so-and-so, or, in discovery, we got this, and so we're going to dismiss it, when somebody actually does everything that they can do to fight the accusations or fight the charges? Does it happen often that sometimes the state will dismiss it, or no?
I've gotten a lot of successful plea bargain cases in my career, where my clients were facing 50 or 100 years to life in prison. In my state of Florida, it's life without parole. Life without parole. You're done. Stick a fork in you. Where guys wind up doing 5 or 10 years, maybe what you might consider a slap on the wrist, maybe some sex offender registration, and maybe a felony conviction. But I have gotten 4 or 5 plea bargains where the felony life in prison was reduced down to misdemeanor, no felony conviction, no prison time, no sex offender registration at all. So I'm not privy to those plea bargains. That's attorney-client privilege, obviously, between counsel and the client. But I'm the go-between that has instilled enough confidence in the lawyer to ask for that with the prosecutor. The prosecutor knows if you go to trial and you got to go through me, through cross-examination,
Hold on a second. You cut out there. Can you hear him, Zach?
No.
We lost your audio, Dean.
And I can't turn it on.
Hold on one sec.
So how's mic's not connected? There. Oh, it was just on.
There it is.
There you go. There you go.
You should be good now.
Okay.
Yep.
Yep.
Right. Sorry about that.
It happens.
So just go back a little bit to where you were talking
have
about
to go
that.
through me to get a conviction.
There you go.
You don't know what to do in these cases, who they're going to believe. Oftentimes in a jury trial, it winds up being me against the kid. I look like the bad guy because I'm trying to impeach the credibility of the child's allegation, Well, just because the kid said it doesn't mean it's necessarily true. It might be a young kid. If you could talk about the Tooth Fairy of Santa Claus, could talk about how Daddy touched my peepee. A lot of studies on this. Back to the 90s, Dr. Cece's book, Jumping in the Courtroom, his article, Suggestibility of the Child Witness. Just a ton of research on this subject. And false memories as well. The false memory case in point, 2017, flashback 7 years ago, Dr. Christine Blasey Ford versus Supreme Court Justice Brett Kavanaugh, national TV, CNN. You recall that one?
Yeah.
And she said that he touched her at a high school party in 1983 or something. Apparently Supreme Court Justice won. This is a psychologist now, and she lost in front of an international audience. So, and the same year, what did we get? We got the Me Too movement. Yeah, you all know what the Me Too movement is, right?
Oh yeah.
Zach, you know what that is, right?
Do know what that is, yeah.
Yeah. So
basically, it's
and I'm not saying that women aren't abused and women are not raped. They are. I mean, you look at Bill Cosby's case, right? So Bill Cosby was convicted, and it was overturned, right? Later on, years down the road, but his case had some forensics. So his case included the date rape pill, I believe. This is just he said in hearsay. So, a lot of my cases are child hearsay. Where the child is telling the parent, or the child is telling the teacher, or the child's telling the babysitter what's going on. And then it basically blossoms into an investigation. You had somebody, you put a message up earlier. Somebody was in New Brunswick about coercive control and was going pro se or something. These cases are real tough pro se. You're going in with a disadvantage because most judges do not like pro se litigants. That is just a general mindset from judges. You don't have a law degree. You don't know the rules of procedure. You don't know the rules of evidence. You don't know the rules of court. No disrespect. You might have done a ton of research, right? Problem is, you're not a licensed attorney. And you're going to be going up against a licensed attorney. I guarantee you that, pretty much. Now, there are some cases where both litigants are pro se. In that case, I would say I might listen to you. But if you come to me and you want to hire me and you're pro se, but there's a lawyer on the other side, I'm probably going to say no. I'm probably going to say I can't help. I just can't. I can't. Risk my credibility that somehow you're going to screw up in court with your questions. Because I can't be feeding you questions, right? I can't do that as a witness. I can only answer. I can't ask. So you're on your own. And,
that's fair.
Look, there are a lot of good lawyers out there. Yeah. There are a lot of good lawyers out there. You got to do the research, and I know it's money. I know it costs money. Unfortunately. Lawyers, they have to charge for their services. I've had lawyers come in from out of state pro hoc vice, right? I've had lawyers come in. I do what I have to do to win a case. But I'm not the quarterback. The lawyer controls the litigation, so I can't tell the lawyer what to do. I can only suggest or recommend what the lawyer does.
Right.
The lawyer can heed my advice or not, and the chips are going to fall where they fall. There's a lot hanging in the balance in these cases.
Absolutely.
And let me tell you, some of these cases some of these cases I have received are 10,000 pages in documents. I mean, you have no idea. You have the stacks of documents that I have poured over. Some of these cases just, I mean, lawyers just don't have time to be going over 10,000 pages, right? They just don't. They got a business to run. They've got an office to run. They got paralegals. They got legal assistants. They've got other clients, right? Court. They have to be in court, right? But I try to do the best I can to get through all those documents and get to the bottom line to help the client and the lawyer. I did want to say one thing about therapeutic visitation and reunification therapy. So in my cases, the false abuse accusation cases, reunification probably won't work. It's a term you get thrown around all 50 states, right? Judges throw it around, therapists throw it around, but in reality, if the child is holding the same belief system as the parent who's governing the relationship, estranging that kid from the targeted parent, reunification therapy is not going to work. There's only two types of therapy that I have read about that work in that type of scenario, where it's a false abuse case, and that is schema therapy and cognitive processing therapy. And schemas are enzymes or proteins that basically modify or alter your memory. And in cases like mine, you can see the fruition of the schemas based on triggers. When you get triggers, and I'm not talking lawyers are trained in law school on motive, cops are trained at the academy on motive. I'm talking triggers, a trauma-inducing catalyst, something that has caused the kid to all of a sudden say, "Grandpa molested me 2 years ago," when Grandpa has never looked at you the wrong way, And so once these schemas are formed in the amygdala, which is the limbic system of your brain where emotions are generated, that can be a problem, because then you can get these alterations in your memory traces and your memories, and that can cause false accusations.
Wow. I was just going to ask you.
Especially, it's so complicated, and there's so many different variables that come into play with each one of these cases that
these cases are very complex.
Mm-hmm. Yeah,
very complex.
I feel like Chuck asked a question about what kind of therapy is the schema therapy and the cognitive, what type of therapy? He's
CPT,
a friend of ours,
cognitive processing therapy.
CPT. Okay.
Yeah.
You're breaking up each time you've said it.
And look, I'm not a therapist. I'm just going from scientific peer-reviewed journal articles and studies that I have seen and read that basically depict that reunification therapy as a whole in these cases does not work, because you haven't changed the belief system. So you have to modify the kid's memories back to when those pictures and audios and videos you have when you had a great relationship with that kid. You have to basically reframe the child's memory to go back in time and say, you know what, all the garbage that I've been coached and indoctrinated and conditioned with is false, right? I've been trained to believe this stuff, and it's not true. And this is a special type of therapy. The therapist has to be certified in schema therapy. So,
and it's probably very few of those.
There are
Richard
some,
Warshak
but
does
not
that
a
work,
lot.
right?
Warshak, he's a clinical psychologist. I don't know how much he testifies anymore, forensically speaking. And great information on parental alienation. That guy, articles and books. We worked one or two cases together. It's been a while, but
Who
I've
are some of
not
the
nothing
up
but
and
great
comers?
things to say about him.
Yeah, who are some of the up and comers? Because I know like
What's
you
that?
talk about Richard Warshak, you talk about like Linda Nielsen, Amy Baker. These people have gone through the system, and they're at the end of their careers or done testifying. Who are some of the up and coming experts that are showing up that you're seeing time and time again that are people that should be looking towards to get information and follow to move this research forward?
Well, I know Dr. Harmon. She had a medical condition. I don't know where she is
Yeah.
on that, but she's fantastic. I mean, she's one of the top docs in the country on PA. Edward Kruk, if you haven't heard about
Yes.
him, Edward Kruk, Kruk,
Oh.
Dr. Kruk is
Love
out of Canada.
Kruk.
He's excellent.
Kruk's
Yeah,
great.
he's excellent. Yeah, yeah.
Yeah, when I wrote my
So
parental
Harmon and-
alienation
You have to
paper,
get somebody. Yeah, and you've got to get an expert who's published in the field, because there will be motions in limine filed, right? There will be Dauber challenge hearings going on, right? Challenging the science of these, challenging the science where the judge is a gatekeeper of the science at those hearings.
Yep.
So you got to get an expert who's published, who's peer reviewed, who has been there, done that, testified, and who's been successful, who has a track record of success. So Linda Gottlieb, out of New York, New Jersey, has a program, Turning Points, right? She's been successful. She's not a doctor, but she's good. She gets a lot of cases. I don't know how many false abuse allegation cases she gets, but she gets a lot of PA cases.
okay, yeah, I have heard of Linda Gottlieb. Haven't talked to her before.
Yeah,
but,
and there may be others. There may be others. There may be others, Zach, that I'm not privy to, because I just have so many cases on my plate that I have to get through in timely fashion, because it just doesn't stop. There are court hearings, there are trials. I'm a trial guy, so a lot of my cases will go to a trial, and the lawyer may decide, yeah, it's too risky to go to trial. You know what I mean? I want to use Dean as an expert, but I can't use Dean to help me pick the jury, right? So we haven't even talked about that, picking the jury in a criminal case, right?
Right.
Well, we got the Me Too movement. We're going to have women in that jury. And I'm not trying to bash women here, but women are very emotional on this sex abuse stuff, right? And so I had two blonde women in a trial of mine in 2011 in Arizona. They didn't even make eye contact with me for 4 hours. I was like Ted Bundy to them. And of course my guy was convicted. He shook my hand before I left the courtroom. He said, "Man, you did a hell of a job." I said, I'm saying to myself, well, I may have done a hell of a job in your mind, but in my mind, you're going to go down. And sure enough, he did, and he got life. Well, the Arizona Republic published a story on him about a month before he went to trial. Arizona's most notorious child molester ever. And I'm saying to the lawyer, what chance does this guy have? The chance of the jury pool not reading that article. Come on, why did you file a motion for change of venue? He said, well, where do you want me to try the case? I said, I don't know, Nogales. Somewhere, but you had to do it in Maricopa County, Phoenix. Where everybody read the newspaper article. Man, come on. So look, I don't get along
right.
to all. Sometimes you'll hear me arguing with the lawyers, right? It happens, I have to move on to the next case,
Right.
and I don't want to disturb any professional relationship I have, but I'm not here to appease or placate. I'm here to try to win. I want to win as bad as the accused wants to win. If you're innocent, if you're innocent, I will give it 110% to put forward that innocence in a court of law with your defense team. But I'm going to put you through the ringer because I'm probably going to require you to go through testing to prove to me you're not that monster that the state says you are. And while I may not be able to believe the kid, I can't believe you either. So that's why you're going to go through the testing. You got to prove to me through empirical raw test data that there's nothing hinky here that shows that I'm supporting a pedophile or a child molester.
Right.
It's just a necessary evil, and
not evil. It's just necessary.
You go to prison. You go to prison. Yeah, well, you go to prison. You're called a chomo, right? Child molester. It's short for chomo. It's called. And let me tell you, today's society, you go to prison for this crime. I can guarantee you, there's gangs all over the prisons now. The shot caller is going to make sure once they hear what you're in for from the guards, your jacket, you're going to get a shank when you get in general population if you get there. Yeah. So it's a situation where this is one crime you don't want to go to the joint for. If you do, you probably want to be in a solitary confinement.
Yeah.
And there are some bad apples out there. There are some guys who prey upon children, who are actual pedophiles or preferential child molesters, as the FBI typology says, and they actually do this crime. So I have to be squeaky clean. I have to vet everybody, including my client. I get cases where guys have been convicted already before. So in my state of Florida, that's called Williams rule evidence, where the state is going to bring in your prior bad act because now you're accused of a similar act against a different kid, right? I've had several of those cases, and so then we have to get what's called recidivism testing on you, whether you're gonna reoffend. So we have to do what's called actuarial testing on you, static 99R, acute stable 2007, to see if you might hurt another kid 30 or 40 years in the future if you're in your 30s right now, for example. We project you out into the future. So that that comes in at sentencing if you are convicted. If you score low, if you score low as a recidivist, a reoffender, the judge might give you a better slap on the wrist than otherwise. You're still going to get time. You're still going to get sex offender registration. You just might not get as much of it as the state wanted you to get. So plea bargains, quid pro quo. You learn that in law school, Zach, right? You scratch my back, I scratch yours, and that's what plea bargains all about. I'm not a plea bargain guy, right? I'm not. You won't hear or see me advocating for plea bargains.
Yeah.
But it's something criminal defense attorneys have to do to move cases along. And it's all about the 4-letter word risk, RISK. It's all about that word. So, that's why I send the accused for risk assessment testing to try to take the risk out of the situation, right?
Right.
And, you go into a case like this, he said, she said, but that she said is a kid. If this is a tennis match, advantage kid, I can tell you, not you, the accused. So, there's something to be said for that. Jurors are humans. These are human beings making decisions on the fate of your life. And this is not a video dress rehearsal. You got one snapshot in time to do this and do it right. And any screw ups, any mistakes, it could cost you your future. So it's very serious. It's very complex. It's not for the faint at heart, and it's not for the inexperienced. And I have worked some cases with lawyers just out of law school. I don't choose the lawyers I work with. They choose me. I don't call lawyers. Ethics prohibits me from doing that. They call me.
Right.
But, and there are lawyers out there who bill themselves as father's rights attorneys. It's a great slogan. It's a great marketing tool, but they suck in court.
Mm-hmm.
What the hell are you doing billing yourself as a father's rights attorney, man? It gets me cases. Okay.
Cases that they lose.
Well,
I get those fees
Yeah.
that we're talking about.
Billable hours.
Yeah. So, I'm
Everybody
just here to
needs to-
do a job and get,
Go ahead.
to phrase the old coach of my New England Patriots, Bill Belichick, do your job, right? And that's what I do. I do it to the best of my ability, and I try to leave no stone unturned. And so I can't convince all lawyers to accept my strategy or my theory. They have their own strategy and theory, or they want this expert or that expert, or they may suggest to me what do I think about this, and they may go in a different direction. That's their prerogative,
Yeah.
Right.
But
Yeah.
the rules of criminal procedure in criminal procedure.
I think the hard part is
the rules. Go ahead.
Oh no! People just aren't prepared for that kind of stuff. You were saying rules of civil procedure, right? That book is complicated. Everything about the law is complicated, and when people try to do this stuff by themselves,
Yep.
and they're going to a case where they're fighting against experts from the state with CPS, they have lawyers who are out there. They probably have 2 or 3 lawyers working for CPS, not to mention all the social workers and the doctors and everybody else who's been out there, and they're all looking for a reason to find somebody to have done this stuff, and they're asking those questions. You need somebody on their side, if you're a defense, like Dean, to go out and do this stuff, right? I mean, that's what it boils down to. You need somebody who knows the business, who understands how this works, and then how to go out there and fight this stuff to protect yourself, because they are out there. The slogan is what always believe the accuser, right? The accuser's right, and I think when I was going through and writing the last bill that I wrote, the domestic violence lady and my professor in law school said, men are abusers, women are victims. And I think when you have that mentality, that's who these people that we're going against, that's what they believe. And they treat these cases like that all the time.
It's true.
Yeah. Well,
So if you find yourself
hi-
in this situation,
I was
you
saying
need
the
to find
rules of
somebody like
criminal
Dean.
procedure trump
Say it again.
the rules of criminal procedure trump the other rules. So it's kind of ironic, because a prospective client will call me. Let's say he calls me and his kid just went for the forensic interview, and he says, my lawyer doesn't have the discovery yet. My lawyer, I haven't been arrested yet. I haven't been indicted or charged by information yet. My lawyer can't file a Brady motion yet, right? Because there's no case against me yet. So if I hire you, you won't have the discovery, will you? And I would tell him, no, I won't. Because the only discovery I get is coming from your lawyer, right? Your lawyer gives me what I need to go over and read or view to help you. Well, that doesn't happen in a criminal case until you are arrested and charged or the investigation is terminated. So the rules of criminal procedure trump everything. and then I get the accused says to me, well, they put my name on the child abuse registry, but CPS wants to back that up. What do you think about that? I said, well, excuse me, but you can't talk right now. Well, what do you mean I can't talk right now? Well, you're under criminal investigation, right? And now you've been arrested. And so just because you've been arrested, but you haven't been charged yet, you still can't get the discovery until you've been charged. But anything you say can and will be used against you in a court of law. So you can't speak. So how could you testify at a CPS hearing? How could you testify in family court? You can't. You can't say a damn thing. You got to shut up. I get more people that, oh yeah, I'll talk to CPS. I'll talk to the police. No problem. I'll give my blood and body fluids. I'll take a polygraph. No problem. I got nothing to hide. I'm innocent. Yeah, well, hey, I understand that's your mindset and that's the way you think it works in America, but it doesn't. It doesn't. And there's another scheme or methodology that the police use. It's called a confrontational, pretext, prearranged, or controlled phone call. So if you're under investigation for abusing a kid, and you are, do not answer your phone from private, unavailable, or restricted, because it's probably the police. It's probably the police. Okay, right. Do not let that go to voicemail. It might be Detective Jones or Smith telling you got to call me, you got to come see me, you got to come downtown, answer some questions. Don't go downtown without a lawyer. Okay, legal suicide. You're walking into a fire pit.
Do not go without a lawyer. I think it should be taught in school all the time. You ask them if you're being detained or not, and you don't go talk to any cops or any situations unless you have a lawyer by your side and they're giving you counsel, because the cops' jobs are to get you circled and make you say something that's gonna get you in trouble.
Yeah, and Zach, I give people that are going to talk to CPS the same advice. Don't talk to CPS. Don't talk to CPS without a lawyer present.
Yep. You don't owe them anything, and they are not your friends. If they are investigating you and they're talking to you, they're your enemy.
I didn't do anything. I got nothing to hide, but I'll talk to them. I let her in my house. I don't have any cameras. I don't have a body cam, but I let her in my house. She had a CPS badge on, and the police said if I didn't let her in, they were gonna force their way in.
Mm-hmm. Hey, we got a question for you from one of the guys that have been on it for a while and stuff. He's talking about. You can read it on the screen if you want to read it. It's probably easier to read it and answer it than for me to read it to you.
Yeah. Well, then you got to, for Chuck, you got to go to court and you got to get an injunction. Your lawyer's got to file a motion for protective order to get mom to stop. All this stuff, cameras, and you have a court order that says you didn't do anything, and she's alienating, but it's not helping you. And it might be a person, a mother who won't take no for an answer. She's a freight train out of control. The only way to make it stop, man, is you got to make it stop. You got to go to court. Your lawyer's got to file a motion for protective order or get a restraining order, injunction for harassment. Whatever the case may be, consistent with your statutes in your state. Then if she violates that, then she's under arrest. You understand? When you get a restraining order, if you text, if you email, if you drive by the house, you are violating the restraining order, you will be arrested. That turns criminal. You'll be arrested. You'll be placed in handcuffs. That's a misdemeanor. So, there are, unfortunately, you're going to have to go to court to get your legal remedy.
Right. I think Chuck has a bunch more questions and stuff. I think, yeah, right. And then they keep running through the mill. Chuck, I think with your case and stuff, go to Dean's website and anybody that's listening and stuff. If you have questions, if you're going through something like this, go to abuse-excuse.com, www.abuse.excuse.com. You can set up for a consultation with Dean, and then he can give you some advice on when to go next, who to contact that might be able to help you out. If he can't do it for you, who you can get. I know, Chuck, your situation's it's very messy and it's been going on for a long time, and so I think a chance to talk to Dean could help you get some resolution and maybe help Dean also understand exactly where you're coming from, because my understanding of your case is it's a lot, and probably more than we can handle here in the next few minutes on the show. So, but definitely go to abuse-excuse.com. So, let's see what we got a bunch of questions and stuff on here, but I think that for the most part, most people are just looking for answers on how do they do this stuff themselves. And I think your big advice is, if you're in this kind of situation, this is not the ball game you want to be doing by yourself.
Yeah.
You get an attorney, get experts, have people on your side, because they have people on their side and they're going to use them. Right, Dean?
Yeah, and and obviously, if it's a CPS case or a criminal case, you're entitled to a lawyer, even if you can't afford one.
Yep.
Now, I understand it's not a private lawyer. It might be a public defender, court-appointed counsel, and it might be a lawyer who has 200 cases on her plate, right? And she can't give you the individualized attention that a private lawyer can. I get that. But in my opinion, some lawyer's better than no lawyer.
Mm-hmm. So you're talking about just
you're going up against a licensed attorney.
Exactly. If they know criminal procedure,
going up against
they
a licensed
know
attorney
evidence.
Well,
Sorry,
even if it's a family law case, petition versus
It's a big
respondent, right?
Mm-hmm.
You go up against mom and your dad. It's about your kid in the middle. What if the judge errs on the side of caution? What if the judge makes a mistake on the side of mom? Because he likes her miniskirt or something. Or he likes the way mom looks. He had a fight with his wife the night before. This stuff happens. So, you really need an attorney. And if the other side has a lawyer and you don't, man, good luck that you don't get your lunch eaten. It's too risky when you have children. I just have so many people like on Facebook that tell me I've wasted, tens of thousands of dollars on lawyers who hurt me more than helped me. And I didn't find you until after lawyer number 4, meaning me, to help with that defense team. There used to be a show back in the 80s. You guys are too young, but there used to be a show back in the 80s called L.A. Law. Google L.A. Law with Corbin Burnson and pull up some of those shows on YouTube back from the 80s. One was on false accusations. I'm serious. This
okay.
This depicted real life. Yeah. Harry Hamlin, Lisa Rinna's husband, was one of the actors on that show.
Huh.
But
all names I've never heard of before.
This is real life. Yeah. Now if it's a restraining order, it's he said, she said. Yeah, I would say save your money. Go ahead and go pro se. That type of case, I would say go ahead and go pro se. But if the government's knocking on your door, they want your kid. Oh man, you got to get a lawyer who's experienced in juvenile dependency, TPR court, right? Who's had success against Child Protective Services. If it's a cop knocking on your door, they're going to arrest you. You got to get a competent criminal defense attorney.
Yeah.
And a good expert like Dean.
and a great expert like Dean.
That's
You know,
right.
there's don't
Experts come later, but
yeah
your
It all
first order
comes
of
later,
business
right?
is counsel, right? To
Right.
defend your rights.
Yes,
yeah
absolutely.
yeah. You got to file forms. You got to do a lot of things, and if you don't have a lawyer who's doing that stuff for you, you could get yourself in trouble just because you don't file the right forms in the right time. And you don't want to get yourself in
Right.
trouble for something like this, for something like that could easily be caught by a lawyer, whether they're proficient in this field or
Right.
not.
Right.
They can at least do those things, and you can then hire Dean afterwards to come in there and advise them, or find somebody else who can help support them in the legal field in your area. Josh asked, "Can you
Well,
be hired in Mississippi?"
yes.
And Josh, he's worked in every single state in the country, and he can work in Mississippi. So go to abuse-excuse.com, and you can get that information right there.
I cannot give legal advice as a non-attorney. I can give expert advice, but I can't give legal advice. So
That's
be
correct.
mindful of that, and
None of this is
and
legal
be
advice.
mindful also that lawyers are necessary to abide by legal procedure, right? Rules of procedure, and the rules of procedure differ in all 50 states. Really, rules of procedure in Wyoming may not be the same as where I am in Florida.
Right.
In California, a lawyer who represents children is called minors counsel. In New York, they're called law guardians. They mean the same thing. They're basically guardians ad litem, GALs.
Mm-hmm.
Yeah.
Lawyers for the kids, right? They
Right.
just have a different name attached to them, but they mean the same thing.
Yeah, every state's a little bit different. I mean, they all follow the federal rules, but they
likewise-
all do it on their own way.
Yep.
Yeah, and the order for protection, right? In Minnesota, it's called OFP. In Pennsylvania, it's called PFA, protection from abuse. In my state of Florida, it's called DVI, domestic violence injunction. But it all means the same thing, right?
Yep. RO.
And so and then also be mindful that there are cases where let's say your wife or your girlfriend you had a kid with, and they're messing around with another guy from another state, and all of a sudden you wake up at 7 a.m. and you're emailing or texting me saying, "Hey Dean, my kids are gone, man, and my wife is gone, my kids are gone, and I got a threatening text from Wyoming, that they're getting emergency jurisdiction in Wyoming, that I'm a friggin' monster, and what the hell do I do?" Well, I said, okay, so they're challenging you got to challenge jurisdiction, right? So mother has violated the Florida UCCJEA if she left Florida, right? The Uniform Child Custody Jurisdiction Enforcement Act, right? She might have violated the Federal Parents Kidnapping Prevention Act, the PKPA, and she might have unclean hands, violating the Clean Hands Doctrine. So you need a lawyer from Wyoming who will challenge the emergency jurisdiction and file what's called a notice of special appearance. That tells the judge that the lawyer is not arguing, doesn't want to argue a mother's merits or her allegations in her affidavit supporting her injunction. He only wants to argue jurisdiction because she has violated Florida's jurisdiction. In other words, we want to send it back to Judge Jones in Florida. We don't want Judge Smith ruling on mother's affidavit and injunction in Wyoming. That would force the kids back to Florida. And I've had a lot of lawyers screw that up because they filed a notice of appearance and not a notice of special appearance.
Wow.
Oh man.
Yeah.
You would think that would be something that would be pretty easy and that everybody would get right because.
Yeah.
Anyways.
Yeah. On its
it's
face,
extremely important, especially when it comes to these cases.
In reality, I mean, one misstep, and man, it snowballs.
Yep.
So,
and you don't know until after it's too late. Once you've made that move, it's too late at that point in time, and it's important to get good counsel. And getting someone with experience makes a difference. And so, getting a lawyer who knows what they're doing, looking these lawyers up on Avo or other websites that give you that information about who these lawyers are and what they've done, and look for somebody who's an expert in this field. Don't just go hire the person that your friend had for his divorce. If you don't have just a normal run-of-the-mill divorce, if you have something like this going on, you need an expert who has done this type of work and take the time and go do that. The state bar knows these lawyers also, and you can call the state bar, and the state bar, in most states, at least in my experience, will give you advice on a bunch of lawyers that you can call who have experience in these fields. So that's an avenue also. But get a lawyer who has experience who can do this stuff, because this is life or death. This is your relationship with your kids, and this could be you going to jail for a long time if it's wrong. And you don't want to mess this up.
Yep.
Well, thanks, Zach. I kind of pulled everything right together.
Yeah,
right together
and this of course being April National Child Abuse Awareness and Prevention Month, right? The month of the child. So
I'm wearing my shirt today. Actually,
it's always a very busy month for me. There you go. Yeah.
Right.
Always a busy month for me. And, CPS actually takes out PSAs, right? Public service announcements during this month to bolster their mindset, obviously this is a money machine. You are not going to compete with CPS's money. I can assure you, they have unlimited resources. Now, if you're Jeff Bezos or Elon Musk or Mark Zuckerberg, yeah, you probably could compete with them very easily. But most people aren't.
I got a question for you. It's going to pop up on the screen here right now from Kara.
Okay, this is going to be the
Arizona.
last one because we got it. We're going to have to wrap this up, Zach.
Last one and wrap it up.
I know we could
totally
just
cool
keep
with that.
going
Let's wrap
and
it up.
going,
So,
but we're going to have to wrap it up after this one.
let's do this one right
You
here.
wanna read
It's all
it?
good. Yeah. How can I get my child returned back to my custody when a judge removes my son from my care? Go ahead.
Yeah, so I think if CPS unsubstantiated that finding or unfounded it or whatever they're in my state it would be unverified is what they call it down here in Florida. That's enough to a pleading. If this is family court that Kara is talking about, your lawyer should be filing a petition for a modification, right? Of parenting time or time sharing is called down here in Florida, based on that unfounded spanking. The spanking did not rise to abuse, right? That was Christian corporal punishment. You didn't leave any marks or welts or bruises. There were no broken bones. There was no medical corroboration of any trauma to the child, right? You were just doing your Christian thing. I learned from a pastor a long time ago, if you spank your kid, follow that spank up with a hug. So the last thing the kid remembers is the hug, not the spank. And so I think that's a simple win for Kara on that one. But if she's pro se, it might not be so easy.
Right.
Yep.
Well, get a lawyer, Kara, and good luck to you. I hope that you get your son back and that you guys can heal and move forward. So, hey, Dean, I want to say thank you. We could probably do this for like 11 hours, and it's been 2. And I know you're on the East Coast. Every time I talk to you, though, it's so
It's a lot of
informative.
information. Yeah.
And this stuff is so difficult and so fact specific, and you really hit so many highlights of the experience. And the books that I've read, some of the books you've already recommended, and I'm going to read the rest of them. But you've done an amazing job. I love getting to talk to you. I love the experience of having our interactions and our communication, and I look forward to doing more with you in the future. I hope that you have a great day.
Yeah.
And do you have anything else you want to say before we call it a good? Yeah. Oh, dude.
Yeah.
You're the best.
And folks, there is some room. I think I've got like 4,940 friends at Facebook, of which I know maybe 50 people over there. But I put a lot of pro bono time at Facebook, informational tips and articles, and and there's a lot of information there. I do recommend people friending me, scrolling down that Facebook page and copying and pasting as much information as you need for yourself to help yourself back in court.
Yeah. No, he's got great
There's a
stuff
lot
on
on
there.
there.
Thank you guys for having me on.
We really appreciate it.
Oh, dude, love you, Dean, man. Appreciate you so much, and the work that you do is so important. It's necessary, and you do a great job. And I hope that you can do this forever. So I look forward to doing some with you in the future.
Well, time. Every person meets their clock, right? So I'm hanging in there, but we'll see on that one.
Yeah.
Thanks for
Keep it
having
going,
me again.
man.
All right.
Anytime, man. Have a great night,
Take care.
Dean. All right. Bye-bye.
That was so much. Wow. So much information. So much great information.
I know. Well,
So
I
much
think we
great
need to
information.
get on our Opus Pro and pull some of that stuff off, because there was so many great tidbits that he gave throughout that live. I mean, it was just unbelievable how much stuff he packed into 2 hours, which sounds like a long time, but it went by really fast. In like 12
It
minutes,
did
I was
go
like,
by
man,
pretty fast. We're pushing 3. I gotta get out of here. I gotta get out of here.
get out of here. Go. You have a good night. And everybody else, next week we're working on a couple different people right now. But I have a call tomorrow. The plan is to have Carnell Smith on, the paternity expert, next week. I'm just by myself. She's got to go. So she has kids to put to bed. My son's at his mom's house. So next week we're going to have Carnell Smith is my intention. I'm talking to him tomorrow to confirm. So I'm just putting it out there right now. Carnell Smith's going to be on next week. And then it looks like we're going to probably have Ryan Powell on in the next few weeks also from Tough. He's been doing his journey through family court and experience about being a dad. And it's been pretty incredible what he's done and been able to relay to you through his live videos. Really powerful and motivating. Pearson on here again. I can't believe he's even awake right now, because his cats have got to be mad right now that he's still up here texting on this live. Your cats cannot be happy, Sean. And so looking to get hit on here. He is a dad who's gone through the experience. He is a father's coach, and he does a lot of great work. He's over there on Tough also, and on KDD, doing some work on helping families and helping people go through this experience. We got a few other people set to come on here. Besides that, we got a few moms that have gone through the experience. I got a dad who's a teacher who I intend to get on here in the next couple of weeks, probably when school gets out. A long list. If you're interested in being on the show, we'd love to talk to you. That's my dog, Barry. He just came around the corner, that side, I guess. And we're just happy to be here and doing this with you guys. Tune in next week. The intention is to have Carnell Smith. You'll see a post up with his image. If not, we'll have somebody else. So have a wonderful night. Thank you guys for tuning in, and we'll see you next time.